So, hi everyone. Thanks again for joining us today, and thank you, Samantha, for speaking. It's great to have you. So,
Thanks so
Samantha
much.
Seabrook is the founder of Seabrook Workplace Law. Samantha helps her clients manage their employment law challenges and set correct foundations in order to succeed, innovate, and grow. Samantha does not overcomplicate matters or oversell. When conflict is necessary, she applies a rational, solution driven approach to control the damage and work with clients to minimize litigation, maximize end goals, and mitigate future risk. Samantha's experience in employment law, workers' compensation, disability, occupational health, and safety, human rights, foundational items, and innovation practices give her an advantageous perspective on workplace law matters. Thanks for your presentation today, and good luck.
Thanks so much, Alex. So I'm just gonna start the presentation. Okay, well, thanks so much for being with us here on a Friday afternoon on what looks to be quite a rainy weekend. So it's been an interesting 15 months. Those of us in human resources, WSIB management, occupational health and safety, all of these worlds, we've really been challenged throughout the COVID-19 pandemic. Certainly for me, I've had to deal with situations I never had thought of before. At the beginning, we were dealing with a rapidly changing legislative environment, health and safety environment, and the practicalities of shifting entire workforces to work from home or implementing very strict and stringent health and safety procedures in the workplace. I know you've all been dealing with these waves of changes, and I think we should all take a second and really, congratulate yourselves for having done a great job in keeping your workplaces safe throughout the COVID-19 pandemic. You're doing a really great job. And now, as we're looking towards the future, I think we're going to be asked to pivot again and to rethink our workplaces again as vaccination rates go up, as restrictions start to be taken away. It's now time to start looking to that future of work and what our workplaces are going to look like in the near term and then the long term. I think we're really going to be in an interim transition period, and then we're going to be looking at a permanent change or permanent changes to our workforce. So with this idea in mind, what we're going to focus on today are key considerations for your return to work plan after COVID-19. We have quite a bit to get through today, but I'm going to do my best to answer questions as we go through. And if you want to pop your questions into the Q&A, I'm going to have some time, hopefully at the end, to get to them all. But as they come up throughout the presentation, please feel free to put them there, and I'll get to them as soon as I can. So the world of work seems to be shifting every day. I feel like 2 months ago, I was reading a headline in the Globe and Mail about expected office vacancies as people shift to permanent work from home. And then this morning, one of the top stories on the Globe and Mail website was titled, "Companies Drop Plans to Sublease Space as More Workers Want to Return to the Office." So we can see that the whole concept of what the future of work looks like is going to be changing rapidly, I think, over the next few months. But despite this recent Globe and Mail headline, what our clients are certainly telling us is that employees want more flexibility in their work, and they want more say in how and where that work is performed. And really, I think we need to get comfortable with the concept of the era of office-centric work, and that it may be over. So with this new thought process in terms of the future of work, what we are seeing are considerations of, hybrid or flexible work models, and that those are really, really here to stay. Certain organizations have either already made that jump this past year or even preceding COVID-19 to having a flexible work model. That could import such concepts of hoteling in terms of desk options, where you log into an intranet and book a desk at work instead of having an assigned workspace. Another key concept that's coming out of COVID-19 is moving more to the idea of paying employees for the work they perform, not for the days and the hours that they put into work. like I said before, employees want a greater say in their work arrangements. They want more choices. They want more flexibility. And COVID-19 has really given rise to new trends, or maybe heightened existing trends, that prioritize meaning and well-being in work and in our lives. So all of these are playing off of each other and forming this idea of the future of work. So our agenda today, we're going to be focusing on these topics about making a return to work plan post-COVID-19. And we're going to take a look at the following categories. What does your workplace look like after COVID-19? Are there changes that are going to be implemented? Are there considerations to temporary versus permanent changes? And then how does that impact in terms of employment law? We're going to look at health and safety considerations, accommodation considerations, and then of course training. So that's a lot to get through in a 30-minute presentation. I may have been a bit overly ambitious in terms of the agenda, but we're really going to focus on the highlights and get some succinct answers for you so that you can start thinking about these things in terms of your return to work plan. And I think one of the most difficult conceptualizations is going to be this interim period that we're kind of on the cusp of now, where we still do have a lot of health and safety measures, IDEL in place, and thinking about how do we move through this interim period of COVID towards the new normal of work, or the future of work. So that's why we have to start planning now, and making a solid plan that will help seamlessly transition through this interim period of time and put in place solid foundations for whatever the future of your workplace looks like. So where do we start when we're making a return to work plan? It starts with an evaluation of your business and how it has changed during COVID-19. So have you transitioned to having all employees work from home? Have you implemented a flexible model where some employees are in the office, some work from home? How has the nature of interaction with your clients, your customers changed? Are you still having employees interact in person? And then how does that look like in terms of moving forward and moving to a new reality where we are able to be in person more and more? So having that idea and that concept in place first is going to be key. And getting back to this idea of employee input, like I said before, employees want more say in how, when, where they work. So we see a lot of our clients are surveying their employees, having discussion with their employees about what they want and how they feel about the future of work in their workplaces. And I think that is such a key element, because in order to have a successful transition, the more buy-in you have from your workforce, the more seamlessly a transition is going to happen in terms of implementing more long-term changes in the workplace. So a lot of the return to work planning is going to revolve around how we answer the question, what will your workplace look like? How are workers going to work? Where are they going to be performing work? Are they going to have a permanent workspace if they're performing work in the workplace? How are those interactions with customer-facing, client-facing roles going to happen? And then, of course, are we changing any kind of compensation model as well? So like I said, pay for work versus pay for time, and pay for days worked. And we have to start conceptualizing this, because it's going to dictate most of the planning that's going to happen. But of course, any change in the terms of employment means that we do have to maybe concerned is a bit of a strong word, but we have to evaluate those changes with a view towards whether or not constructive dismissal could be on the table. Now, we're in a period of time where the concept of constructive dismissal is a little all over the place in terms of the infectious disease emergency leave, and I'm going to touch on that a little bit later in the presentation. But the key thing is identifying, what's staying the same, what's changing, how is it changing, and what impact is that going to have on the terms of employment. And when we look at the terms of employment, great place to start is your employment contracts. And hopefully we all have written employment contracts in place. It's very, very helpful and very useful in these times. Now, a lot of contracts do talk about the location of work. And, likely says something about you will perform work at the company's head office, 123 Main Street, et cetera, et cetera. Now, hopefully, your employment contracts contain language that gives the employer the ability to change the location of work within reason. There are circumstances in which a location change can trigger a constructive dismissal claim, but it's not to say you can't change the location of work. It's really about what's reasonable in the circumstances and whether or not there's been a fundamental change to those terms of employment. And this is always an interesting consideration when we're talking about not really changing an office location per se. Most of the discussion right now is happening in terms of work at the workplace or work from home. But a great starting place when we're looking at a permanent change is to look at what your contract says. And if your contract isn't giving you the language that you would like, it's time to look at revising those contracts and how you can implement that going forward. And even if you've been 100% remote working, work from home over the period of COVID, I think the courts will see a difference between a temporary arrangement, although the word temporary becomes a little bit interesting after 15 months, but a temporary arrangement due to a pandemic versus a permanent shift of the workforce to a different working environment. So, hopefully, like I said, hopefully your contract gives you the right to change the work location for business reasons. But when you're looking at that language, the evaluation should be in light on what rights and responsibilities does it give the employer in terms of changing the location of work. Changing compensation models. So this is a bigger concern for constructive dismissal. And I wanted to include this because I'm sure we've all seen in the news, particularly Facebook, that some companies are thinking about implementing a reduction in pay if workers move to a different city to perform work from home. So the company has shifted entirely to a work from home model, and then they're looking to implement a pay reduction if someone moves, in Facebook's case, from San Francisco to another area with basically a lower cost of living. This would be constructive dismissal in Ontario if the pay reduction is significant. And generally speaking, the general rule is that a 7% or more change in compensation can trigger a constructive dismissal claim. So if you're thinking about implementing something like this, please speak to an employment lawyer and get an opinion on whether or not you're looking at constructive dismissal in the circumstances of the compensation change. And then also we need to consider, if we're changing the model of compensation, like I said, this concept of pay for work versus pay for time is getting more and more traction. And that's why I wanted to address it today, because it's an interesting concept and it plays very well into the conversations that are happening around flexible work arrangements. And flexible work arrangements are great. But when we look at changing compensation models, we do also have to look at how that interacts with the statutory regime. the Employment Standards Act. Unfortunately, the Employment Standards Act is not keeping pace with the change of work environment and flexible work arrangements, and in particular, this idea of pay for work versus pay for time, because the Employment Standards Act is very much based around this idea of paying for time spent at work. So concepts about accruing vacation pay, vacation time, how do you calculate overtime hours or track overtime hours in this kind of pay for work environment? Other considerations can come around employee incentive programs, that are attendance based. So if you have those kind of incentive programs in your workplace and you're looking to change your compensation model, it's time to go back to the drawing board and rethink how this is going to work, both from a statutory compliance perspective, but also how it's going to work for the particularities of your workplace. Okay, so there's a whole presentation on vaccine policies just in the session before. So this is very high level, and this topic is definitely more worthy of an in-depth discussion, but I didn't feel I could get away with talking about the future of work in this interim period of time without at least touching on whether or not employers can implement a mandatory vaccine policy in their workplace. Bottom line, we're telling our clients, don't mandate vaccines unless your business reasonably requires vaccinated workers. And that's really, I think, going to be the entirety of the analysis if and when this comes to litigation about were mandatory vaccines reasonably necessary and rationally connected to your workplace. So for example, if your entire workforce is work from home, they're not interacting in person, they're not visiting clients and going around, is it reasonable and rationally connected to the workplace to have a mandatory vaccine program? It's possible that an adjudicator would not find the reasonableness and the rational connection to the workplace in those circumstances. The other consideration that employers really need to think about is, how are we going to manage this from a human rights perspective? And in particular, you have to be careful about accommodation for disability and for religious beliefs. So those are really the two human rights grounds that are going to be in play when we talk about mandatory vaccine policies in the workplace. And it becomes a bit tricky when you think about implementing this, practically speaking, about having your workers provide proof of vaccination, for example, and how do you deal with a worker that isn't providing proof and then asking them questions about a disability they may or may not have or religious beliefs they may or may not have. So it becomes it really does become a minefield if we're implementing this in a workplace that, again, may not reasonably be expected to require this kind of policy. The other tricky part is the privacy considerations for employee health information. So you'd be basically asking employees to provide proof of vaccination, which can be considered health information. And it's interesting to think about it in terms of COVID-19, because the way we've thought about privacy considerations in the workplace has already dramatically shifted in the last 15 months. I don't know if anyone out there has implemented this in their workplace, but mandatory temperature checks. Who would have thought 15 months ago that we would be collecting that kind of information about employees in the workplace? So there is this rebalancing of privacy considerations that's happening during the course of COVID-19, but certainly that's something that needs to be considered if your organization is considering implementing a mandatory vaccine policy, about how you're going to collect that information, and then how you're going to store it and keep it confidential. Of course, when we consider the future of work, there is the ever-present Section 25(2)(h) of the Occupational Health and Safety Act here in Ontario that implements an obligation for employers to take every precaution reasonable in the circumstances for the protection of a worker. And this section of the Occupational Health and Safety Act has certainly been most at play during the entirety of COVID-19. And what this means, what it means to take every precaution reasonable in the circumstances is very dependent on the type of workplace that you have, and thinking about how work is performed and the potential for exposure to COVID-19, and then how that changes as the landscape of COVID-19 changes, especially in this interim period that we're entering into. Because there's going to be different precautions that need to be taken when there's public interaction versus 100% work from home, of course. So we need to again have that concept of where is our workplace now, where are we going in the interim, and where are we going in the long term, so that we can implement the correct occupational health and safety precautions so that we're complying with our statutory obligations. And we need to consider too, as if your workplace model is changing, how you do business is changing, you need to consider the impact on your health and safety programs, right? Because you do have general occupational health and safety obligations in terms of having basically an occupational health and safety plan that's tailored for your workplace. Also violence and harassment assessments, etc. And those have to be evaluated and adjusted whenever there's a change in the workplace or a significant change in the workplace. Generally speaking, you should be looking at your health and safety policies, procedures, etc., on an annual basis, and that includes your workplace violence and harassment policies, by the way. But you have a requirement to revisit these policies and procedures whenever there is a significant change in your workplace. So, there already has been for most of us with the shifts home. Now, if we're shifting people back to work and that work environment looks different, now is the time to go back and start assessing about what the landscape of occupational health and safety looks like in your workplace. Also, at any point when a policy or procedure changes, you should really be looking at retraining your workers. And this is a great opportunity to start thinking about that retraining. We're talking with our clients about, the clients that are looking to shift a lot of people to working at the workplace again, about just doing a general retraining on, employee handbooks, expectations, health and safety, harassment, violence, discrimination policies, helping workers prepare and start maybe mentally transitioning to be ready to return to working in the workplace again. But even if you're having everyone work from home in the interim or in the long term, it is a good opportunity to revisit that training and reorient everyone to either your new policies and procedures or your old policies and procedures. So this accommodation is going to continue to be a focus, particularly, I think, during this interim period of time. And what we've been seeing the most requests for accommodation are in the areas of family status and then in disability, which I'll get to in a minute. So in terms of family status, going to be a major consideration still. And then, of course, we have to think about what's going to happen in September, particularly with the unclear status for vaccinating children and how that's going to impact on a number of factors. So there's still going to be this obligation to accommodate people that have family status accommodation claims in your workplace. And so I just wanted to put up for you a reminder of what the test for family status accommodation is in Ontario. So the employee has the obligation to show a negative impact on them that's based on a family need that's resulted in real real disadvantage to the parent-child relationship. And of course, that can be both for parents that have childcare responsibilities, but also children that have parental care responsibilities. And that there's been a real disadvantage to that relationship. The Human Rights Tribunal is going to assess any alleged impact contextually, and they can consider whether or not there are other supports available to an applicant. So was there someone else available to provide child care or elder care? Were there, other child care supports available? So that can be part of the discussion with the employee when you are considering family status accommodation. And then, of course, if a claim goes to the Human Rights Tribunal and the applicant can prove the first two elements, the onus is going to then shift to the employer to show that they could not accommodate, either the applicant did not have grounds for family status accommodation, but if they are able to prove that they did, then the employer has to show undue hardship. I could do a whole hour, 2 hours on undue hardship, but it is a very high threshold. And especially considering the major changes that have happened this year, consider how that will impact on an organization's ability to show undue hardship if the accommodation request is, for example, to continue to work from home when the employee has been working from home for 15 months. One other thing I wanted to touch on before moving on is the procedural element of all of this. Even if someone comes with a family status claim and at the end of it, they didn't really meet the criteria for family status accommodation, it's incumbent upon the employer to show that procedurally they fulfilled their duty to accommodate obligations. Basically, that they investigated the request for accommodation. You can't just dismiss it out of hand. You do need to make inquiries. And we are seeing cases where there's significant damage awards for employers that just don't engage in that procedural element, that they make a cursory decision without information. And we're seeing awards, human rights damages awards in and around the $20,000 range for failing for failing in that procedural element. So like I said, accommodation for disability is also going to continue to be a major consideration going forward as we're still dealing with COVID-19 and those that, particularly those that might have a higher susceptibility or high risk for COVID-19. Again, like I said before, in terms of mandatory vaccines, that this needs to be a big consideration. How, if you're going to implement that kind of policy, how you're going to account for people with disabilities that mean they can't get a vaccine. Also want to touch on the infectious disease emergency leave, IDEL. It has been extended until September 25th, 2021. There are now 3 days of paid leave for certain categories of people that need to be on infectious disease emergency leave. The IDEL is also going to affect family status and disability accommodations. The workers that fall within the eligibility criteria because they need to engage in childcare or care for someone else, or have contracted COVID-19 or been exposed, can be entitled to the IDEL, and that is a protected leave under the Employment Standards Act. The other point about IDEL that needs to be touched on is the concept of constructive dismissal. So basically, when the infectious disease emergency leave was implemented, for those that have potentially fallen into a constructive dismissal claim because of a COVID-related circumstance, either they've been on layoff or they've had their hours reduced, the IDEL purports to say that that is not a constructive dismissal in Ontario. We now have 2 recent court decisions on infectious disease emergency leave and constructive dismissal, and they both say 2 different things. There's the Cotino decision that says IDEL does not displace the common law, and that constructive dismissal is still a claim available to employees who were laid off or had hours reduced due to COVID. And then we have Taylor that says that the IDL does displace the common law. So we're still in uncharted territory. We don't know what the answer is going to be. Those cases are going to the Ontario Court of Appeal, so watch them because it's going to play out in how you do your workforce planning. Keep this date of September 25th, 2021 in mind. If you still have employees on layoff, if you still have employees that are on reduced hours, this can affect whether or not they're going to be able to claim constructive dismissal either now or after September 25th. So I see that I'm kind of at my end of time. One more slide. If your employees don't want to come back to the workplace, if they don't have any real grounds to say they can't come back, we're recommending a measured approach, following your progressive discipline policies to gently take those workers to where they need to be, hopefully back to the workplace, or setting yourself up for a termination. So these are our key takeaways for today. You already have the tools. Really, we want you to be reasonable and be creative. And I think that's going to take you very, very far in formulating an effective return to work plan and keeping your businesses successful along the way. So thanks so much for being with me today. So you see that we don't have any questions in the chat. So if anyone had any, they can put them in there now, and I'd be happy to answer them. Okay, well, thanks so much for being with us today. I know it's time to get to the last session of the day, the panel for today. So everyone have a great afternoon and a great weekend. Thanks so much.